Hi everyone, thanks for joining us for our ePractice Manager webinar. Today we're joined by Tim Bowles, who is a graduate of UC Berkeley and UC Davis School of Law. He's specialized in employment law and litigation for well over half his career, earning Martindale-Hubbell's AV rating, which is the highest possible. He works out of Pasadena, California, where he has a firm that has helped thousands of businesses, including a lot of dental practices, successfully handle workplace discrimination, harassment, retaliation, and wage-related claims. He also regularly assists employers to develop policies in the prevention of personnel problems. He's here with us today to discuss the suddenly new legal realities in and during this COVID-19 pandemic. Tim, welcome. Thank you for joining us.
Thanks, Gillian, very much. It's great to be here, and I appreciate the opportunity. All right, so let's get started. So first off, this is our own California, and I know I'm speaking to folks from across the country. You're going to have similar developments already, or they're upcoming. This is from our own Governor Gavin Newsom, and this was about 2 weeks ago now, where he directed that all folks living in California, except as needed to maintain the capacity of operations of critical infrastructure, are to stay home. Now, the 16 areas do include healthcare. So we can, yeah, there you go. And they do include healthcare. So how does this balance out? Well, now in the states where we do have these stay-home orders, you can see on the right-hand side of the slide, as of 3 days ago, we had 30 states with orders in one form or another of stay in place, shelter in place, stay at home, safer at home, all in the same concept here, to limit to the extent possible our travel and our interaction with each other. And here in Los Angeles County, we've now closed all the trails, parks, and fire roads, which, well, I don't know if that's necessary, especially when you're walking at 5 o'clock in the morning. But there you have it. We're dealing with a new world. All right, so here you see the advisories, and this is where the line is being drawn in the dental world. The ADA has indicated that concentrating on emergency dental care will allow us to care for patients and alleviate the burden. California Dental Association strongly recommending that dentists suspend all in-person dental care, exception of emergency treatment, until further advice. So this is the line. We have really a gray area for dental offices across the country, in that we want to continue providing the emergency care, but on the other side, it's not our full operation. Many businesses have to shut down, as many of us know, shut down completely. But we're being relied upon, of course, to maintain the infrastructure in terms of public health. So this is a new world, and we have a situation where some of the laws regarding what we can and cannot ask employees have been turned on their heads. We are probably familiar with the Americans with Disabilities Act, and its play in the workplace includes the inability for managers to reach out and take the initiative. If somebody's sick, you can't actually ask them what their diagnosis is. That's a prohibited area, has been for decades. But we're in a new world, as I said. So the Equal Employment Opportunity Commission, which is the federal agency in charge of employment discrimination, has issued, they've actually taken out from 2009, when H1N1 was in play, the set of guidelines that were created at that time, and have fine-tuned them for COVID-19. So who should be isolated? The isolation is the actual singling out of people that have been that are suspected they're actually ill with this disease. Now, this is a gray area. The CDC, as I say here on March 24th, stated in their website that limited information is available to characterize the spectrum of clinical illness associated with the disease. Most patients confirmed with 19 have developed fever. It may be subjective or confirmed or subjective, and or symptoms of acute respiratory illness, such as cough and difficulty breathing. In our own area, the county health department here in LA has indicated that all diagnosed or likely to have 19 must isolate themselves. Likely to have now. And this is taken from Kansas State Health Department from a couple of days ago. You can see the overlap. So this is the gray area. In LA County, we have a directive that if someone has a symptom that goes in the column under 19, COVID-19, they're to be isolated. Now, that doesn't necessarily mean they have COVID-19 because flu and allergies overlap with it as well. But as employers, we are asked to take the initiative here, and we can take the initiative to ask somebody to go home and isolate themselves under the CDC guidelines, which are 14 days to stay away from other people and certainly stay away from the office. All right, now that's as opposed to quarantine. Quarantine carries with it this concept of close contact. And how we define that is a moving target as well. I think there's going to be more and more specifics issued, but the CDC has told us that a close contact is being in approximately 6 feet of a COVID-19 case for a prolonged period of time. What is a prolonged period of time? The CDC, our federal authority, doesn't tell us what that means. It can mean, of course, somebody being cared for or who is diagnosed with this. It can also be someone who's had direct contact with secretions or excretions, coughing, sweat, and so forth. Our local health authority has tried to define that more closely by saying that close contact is 6 feet or for more, within 6 feet or for more than 10 minutes, or unprotected direct with secretions, and they're more specific with their examples, sneezing, coughing, and sweating, of a person diagnosed or likely to have COVID-19. Likely to have. That's the symptoms. That's the chart that we went back to before. So this is a wide-ranging order in LA County, at least, that indicates a wide range of people that may not even have it, but LA County is not taking any chances. If you've got any of the symptoms, that person is to be quarantined, which means, stay home. They don't have to have the food served through the door, but they need to stay in place until they're sure in the 15 days. And I said isolation is 15 days. Isolation is until the symptoms go away, and then beyond that, I think it's 72 hours. There's things you can find online on that. Okay, so that was great. This is the next thing, and the CDC will tell us nothing about this. I don't find this in any of the FAQs. There are some law firms that have issued some views on this, but it's the duty to others in the workplace that we'll see more and more clarification on. At this point, this is my best judgment. Again, this is not legal advice, and it takes the form of case-by-case judgment to work this out. But what I believe is a best practice is a written policy, which we've developed in the last week or so here in my office. You can write us and inquire about that. A written policy which includes a passage. It would go through all the different aspects of what our new duties are, and I've outlined some of those in these prior slides, our new obligations and our new prerogatives and abilities as managers. But it also indicates the policy that in order for us to help all employees and their families take all possible precautions, we are asking anyone who's been diagnosed or showing symptoms to give the consent for us to disclose to management. We would ask them rather to us with whom they've been in close contact with within the workplace. So we can then take the action to have those folks quarantined. And beyond that, to give us the consent to identify that person, the person with symptoms or diagnosis of 19, to identify that person in management's own inquiries to company employees to determine who, if any, have had that close contact. So again, a new world. But this is our take on best practice. And again, we're happy to give this to you as part of when you write in. Again, not legal advice. You'd have to check with your own lawyers or consult with us on how this might actually apply to your scene. So many of us have the ability to maintain operations, and some of our staff that aren't able to work in the office on emergencies, but perhaps are using, perhaps they're front office folks, perhaps they're doing appointment confirmation, they're answering the phone remotely on call forwarding. They may be doing marketing activity or promotion activity from home. These kinds of things that are still feasible to keep your practices going. And by all means, that's the whole idea here, is to work together to survive this. We want all of our clients in every field, including dentistry, to use every resource necessary to get through this very challenging, unprecedented period. And of course, one of those things is telework, as I mentioned before. So, and we're helping clients develop policy in this area. These are some of the bullet points that are things to think about: equipment to maintain, to obtain, to bring home. The issue of reimbursement if someone's using their own cell phone, if they're going out of pocket for office supplies, that kind of thing. Recording of the hours. In California, we have perhaps the most stringent employment regulation of just about anywhere. I guess New York is in tight competition with us, but we have our rest periods and meal breaks here, and they and accurate tracking of recording of work hours. And then you have the question of some folks can work in a solid block of time at home with schedules and so forth. But we do need good documentation that they actually did start and finish their time. They did take their breaks. They did take their meals as required under state law. California, a 30-minute meal period before the 6th hour starts, uninterrupted half hour. So that's important. And to minimize background noise, as it says here, and distractions while interacting with others in work conference calls, etc. Again, this is, can be and should be articulated in policy, but how do managers oversee and supervise productivity remotely? If you're on some system of metrics or statistical tracking, that could be one way. But this Zoom that we're now familiar with, that we're becoming familiar with, is another tool. For example, my office meets on a daily basis in ways that we hadn't actually met before the crisis. We're meeting more often now than we were before. So businesses can make this an opportunity out of a crisis. And of course, protecting equipment, and very important in the healthcare field is communicating the expectations of privacy and confidentiality, the HIPAA requirements on disclosure to unauthorized persons' health information. So that's an advice that remote people working remotely need to take to heart. So the teenage son isn't overlooking some health information. It's being safeguarded. Okay, so let's talk now about the broad issues of leaves and unemployment. And as we enter this whole realm, we want to make sure we understand that the two are distinct from each other. You don't have both. There are situations, I guess, where they could potentially overlap, but for the most part, what we need to keep in mind is the distinction between the two. I actually will talk about how they do overlap in one instance. Leaves are benefits granted to employees when the person is not able to perform work due to COVID-19. So in other words, the office is open, the business is going forward, but the actual individual employee is not able to participate in that business, whether it's at home or whether in the workplace itself, because of some COVID-19 related circumstance. They may be sick, they may have to take care of their young one, et cetera. We'll get into the criteria for what qualifies for a leave in a few minutes. But at this point, I want to just lay out the conceptual distinction. An unemployment is a situation where the employer is unable to provide the work due to COVID-19 related circumstances. So leaves are when we would like that person to work, but they're not able to due to their personal circumstances. Unemployment is where the employee would like to work, but the employer is not able to take them on because of pandemic circumstances. All right, now this is California, and I'm going to briefly go over some of our specifics, but if you're in another state, rest assured that your own agency that's responsible for maintaining unemployment insurance benefits will have websites to give you the specifics on this and give your employees specifics, perhaps more immediate concern is to them, because we are sending them out, unfortunately, under these circumstances, and we can't provide them with the benefits of a leave. Now, if it's unemployment that an employee is going to have to turn to, in California, and I'm going to surmise that you'll find this in other states, hopefully all other states as well, unemployment eligibility is not just for being laid off on a full basis, but also for reduced schedules, which is some good news. Someone's back to 6 hours or 4 hours from a normal 8-hour or 10-hour schedule a day, then they can make up the difference by applying for unemployment. In this state, this is a confirmation of the reduced hours. If you are temporarily unemployed due to COVID-19 and expect to return from work in a few weeks, you're not required to actively look for work each week. So look in your own states for a similar provision. This is where the employer can help the employee. We don't know when this crisis is going to pass. There are a lot of anecdotal suppositions and projections about this, but it may last for several weeks, several months. We don't know. So in California, if the proposition is left open, but we really want to have these folks come back, the proposition of how long it's going to last is left open, but we really want to encourage these people to come back, then of course we want to make that communication to them have to be out on unemployment, that we want to restore the status quo as soon as possible. Here, that means they don't have to look for other work, which is good because we actually like them to stick around and return. You may also find this in your own state. If you're in California, our governor, someone out on the street, so to speak, is now able to apply online at that very instant. They don't have to wait. Other states, I learned in Florida the other day that I think the waiting period is something like 3 weeks. So that's the situation there. But you'd have to check with your own state to see whether these waiting periods are waived. I would hope so, and I would expect that's the case. Now, there's been a lot of talk about whether one is actually furloughing or laying off employees. And I asked the question in this slide whether that's a distinction without a difference. Typically, a furlough is an individual who is still on payroll, someone who is being maintained on the rosters, if you will. They aren't necessarily paid for the time, but they are out for the time being, and they are still part of the workforce until conditions change. The typical example of that in some instances were businesses which furlough all their employees over the holidays. They might provide a vacation pay, they might provide other benefits, PTO, paid time off, but these employees are so-called furloughed because there's actually no change in their status as employees, maintaining their seniority and so forth. A layoff, on the other side, is understood to mean that there is no connection with the company any longer. They're actually being terminated, to use a harsher word. But for the time being, at least, they are not on the payroll, and they're not participating as any sort of employee. Their status has changed to unemployed. In California and in, I presume, many other states, we have a rule that if you're laid off, all your pay and all your accrued vacation, all your benefits that you have had coming to you have to be paid on that day. Otherwise, in California, we're going to have the liability as employers of paying penalty wages of their daily rate of pay for up to 30 days in addition to what we otherwise owe them. So in these states, in California particularly, it's a mistake to lay someone off and then wait till the next payday to pay their last pay. And again, we're happy to answer specific questions on an individual basis on any of this and how it works if you're able to contact us or you would choose to. Now, I say it's a distinction without a difference because here in California, one to be furloughed has to be on a very short timeline to return. Either they're going to be, the employer has to specify the return date as within the current pay period or 10 days, whichever is shorter. And that means that if you have got a 14-day pay period, for example, and you let that person out on the Thursday before the end of the last Thursday before the end of that 2-week period, you've got to pay them. You've got to return them rather before the end of by that next Saturday or Sunday when the 14 days ends. Or if 10 days is shorter, you've got to bring them back. Now, if you don't do that, if you haven't committed to that, then the so-called furloughed worker is unemployed in California. And that means they have to be paid their final paycheck on the day they are furloughed. So whether you call it a furlough or a layoff, if they're not coming back on a specific date here in this state, within that those short time frames, then they've got to be paid their final check. Now, again, I'll just touch on this briefly. California has a flexible unemployment alternative, which involves teamwork, and that is that the employer is now actively participating with its own staff to share the burden of to have all the employees, the workforce, share the burden of reduced schedules or having to be off work. And this is a workout of a work sharing, so that across the boards or within a certain section of their employment force, there's a reduction in salary and a reduction in hours. And if you want more information on that, it's online, or we can help you with that on a one-on-one basis. Okay, so now we're going to talk about the different leaves that are coming up. And this is all brand new. The so-called Families First Act, Families First Coronavirus Response Act, and there is the acronym FFCRA, has been in effect since yesterday. It was passed a few weeks ago, but its effective date was yesterday. Now, it involves three main parts that are of concern to ourselves here. The first part is emergency paid leave. The second part is the emergency family and medical leave expansion, and then the tax credits. So in all of this, the broad concept here is actually the federal government's attempt, I think, to avoid the crushing burden to the state governments and federal government on unemployment compensation. And I saw a news story this morning that some 5 million people applied for unemployment last week. That these are an effort to transfer the economic needs of the employees that are now no longer able to work to the pockets of the employers on a short-term basis with tax credits on the other end. So it's designed to require us as employers to foot the bill, if you will, for the short-term emergency paid leave, as long as it's COVID-19 related. On the other end, there are taxes that we do not have to pay to 100% matching to the out-of-pocket amounts. In the emergency family leave, this is the one that's for longer term, for 12 weeks. The emergency paid sick leave is for the equivalent of 2 weeks of employment, whether it's a full or part-time. Okay, so this is boiled down, but the paid sick leave, the emergency paid sick leave, is for 80 hours of paid benefit for full-time employees and 2 weeks of average hours for part-timers who cannot work or telework for 5 COVID-related reasons, and I've got them in the next slide in more detail. Now, on the other side, or contrast to that, is the family leave expansion. Now, this, in some sense, picks up where the paid sick leave leaves off, but it's only for very specific reasons of absence, and that is to care for a minor child due to a COVID-19 school closure or childcare closure. Now, this adds on to the Family and Medical Leave Act, another federal law. And again, a new world. The FMLA, the Family and Medical Leave Act, applies to payrolls of 50 or more. And I'm going to gather that for the most part, our listeners as dental offices are going to carry payrolls of less than that amount. But in this new world, this emergency expansion covers employers that have 499 employees or less. So that can go down to 1. And the paid part of it, as it says here, is after the first 10 work days. The rate is not less than 2/3 of the regular rate, and a $200 a day cap and a $10,000 total cap per employee. So again, a new world. But let's see how this works. These two laws were made to complement each other. So the Emergency Paid Leave Act, as I mentioned, is for 2 weeks of pay. If it's full-time, that's the equivalent of 80 hours. The family leave expansion does not pay for those first 10 work days. And it would only kick in after that time. And it only kicks in for this 12-week period up to a cap of 200 a day and 10,000 total. So theoretically, you can have someone who is absent for childcare during that first 2-week period. They continue to have to be absent beyond that, in which case they're going to get 2 weeks of regular pay from the managers or from management. But you could theoretically run out of that 12-week period for the remainder, in which part of that would become unpaid leave if the $10,000 cap is reached, at which time the person would turn to unemployment benefits for that time. Now, a lot of questions have been asked about this. As I say, the developments are daily. Yesterday, the Department of Labor issued their temporary regulations on all this material. They have FAQs online, which have been changing every day. As of 2 days ago, they had 58 questions, and they continue to expand the answers, questions and answers. We know for sure at this point that these leaves can be taken intermittently. It may be that the 2 weeks of emergency paid sick leave, it can be taken for part-time leave, for leave that starts and ends and starts again, as long as it's all within the next several months, ending on the 31st of December. And the same goes for our Family and Medical Leave Act. Okay, now I'm not going to recite these verbatim, but there's some interesting points here. These are the 6 reasons that someone can be out on a COVID-related emergency sick leave in these first 2 weeks, these first 80 hours. And if you're part-time, it's not an 80-hour benefit. It's the, as I said, it was the average number of hours you work over, that person would work over a week's time or 2 weeks' time. So a part-timer might be working 32 hours a week. The benefit coming to them under this law would be 64 hours of time and pay. And it's full pay. It's their regular rate of pay for this 2-week increment. The grounds include subject to a quarantine or isolation order. If they've been advised by a healthcare provider to self-quarantine, if they're experiencing symptoms, and, this is a big and, seeking a medical diagnosis. They can't call in and say, hey, I got a sore throat and qualify for this leave. They also have to be actively seeking a medical diagnosis to see whether it's 19 or whether it's one of these other conditions that might display the same symptoms. If they're caring for an individual who's under a quarantine or isolation order, they can be qualified, or they can be caring for a minor child whose school or child care has been closed due to 19. In some of the clarifications, the FAQs and in the new regulations now issued temporarily and on an interim basis yesterday, it's clarified that if you're caring for a disabled child who perhaps is not under 18, that can qualify, as long as it's, again, due to closure of childcare or school due to 19. And this, again, is a moving target and a work in progress. As of last week, the Department of Labor indicated in a memo that they are not going to enforce the various aspects of the Families First Act for violations through to 3 weeks from now to April 17th, meaning that if an office is using good faith efforts to try to comply, to try to understand what this law means and how it fits together and who qualifies and who doesn't, then there's an interim period here, a moratorium on enforcement and penalty. Okay. As of yesterday, we also have the requirement to post and disseminate the employee rights poster under the Families First Act. The issue is what constitutes notice, and best practices. I would suggest best practice. Of course, you post it at your workplace, but if no one's there, or if only some are there and not all, you'd also want to distribute this as a PDF email attachment. All right. Now, this is, again, a resource. This can be Googled, Department of Labor, FAQs. It's changing every day, as I mentioned a few minutes ago. We were up to 58 answers Tuesday, I believe it was. I haven't checked yesterday, so we may have even more. I know we can't cover everything here in this short amount of time, but there are many questions that will be answered for you at that website. Now, there are exemptions, and you've probably heard about this. There are exemptions which the public understands. If you're a business with less than 50, you might be exempt from some of this law. There are other anecdotes going around about folks being, or businesses being exempt from all or part of this law if you have less than 25 on your payroll. And there are also exemptions in the law for healthcare workers. So I asked the question, are dental offices, small business defined as either less than 50 or less than 25, going to be exempt? Well, here's my answer. I'm a lawyer, maybe. Now, there's a small business exemption, and here is small business being defined as fewer than 50. This is an economic exemption. This is an economic hardship exemption, and it's an exemption which has these criteria. The FAQs, and again, this is from 3 days ago, that the government answered that those with 50 or less than 50 are exempt from providing paid sick leave due to a school closure, if doing so would, again, fine print here, these are 3 reasons that one would not have to pay out the 2-week short-term sick pay or the Family Leave Act pay beyond that, if the provision of it would result in expenses over revenues and cause the business to cease operating. The absences would entail a risk to the practice's financial health, number 2, because of specialized skills, or there are not sufficient able, willing, qualified workers who will be available to perform the needed services. And these labor and services are needed to operate at a minimal capacity. Okay, well, that's a mouthful, but the next question is whether we have to apply for the exemption or not. The answer to that is no, you don't have to apply. It's a self-applying exemption. Of course, what we want to do is avoid this kind of thing and get us all through this period of time. Now we have the healthcare providers exemption, and there's a bunch of questions and confusions that are swirling around this. The actual law says that the Labor Secretary has the authority to issue regulations to exclude certain healthcare providers by allowing the employer of these providers to opt out. Now, who is the employer of a healthcare provider? Again, FAQs. So we had in March, that was Monday, this answer from the Labor Secretary, that a healthcare provider is anyone employed, not just the dental specialist or the doctor in a hospital, but anyone employed at a doctor's office, healthcare center, clinic, etc. And this includes any permanent or temporary institution. And this is to minimize the threat, but the department also encourages employers to be judicious when using this definition to exempt. So this is your appeal to good faith. And again, a moving target. But the idea here is to balance the need for delivery with the economic survival of the practice and of our workforce as we maneuver through all of this. So we got to stretch to see whether we can make these leave benefits as best we can. And of course, we're going to get into the Carreys Act in a minute, this brand new law, which is providing some economic relief to try to balance this out and to cover the hardships for payroll of people that may not even be earning revenue for the company or the practice. All right, so this is a long slide. We won't have a quiz on this, but it's just to indicate that the ADA and a whole coalition of dental organizations are reaching out to the government for clarification and a request to make dental offices a a group exemption if dental offices choose to do so. The interesting point of this was the final paragraph, which asked the secretary not to require anybody to apply for an exemption. This was written 2 weeks ago. And of course, we now know from FAQs that we don't have to apply. So this may have gone by the boards. And anyway, this is the ADA attempting to help the entire field. All right. So we come to the Carreys Act, Coronavirus Aid, Relief, and Economic Security Act. This is brand new law. This was passed, I believe, signed into law on Saturday. The draft of the law as of yesterday was all one could access online. The official government website, which publishes final law passed into existence signed by the president, was not even online 2 days ago, yesterday. And so what I'm outlining here, with some confidence, I'm telling you, is going to be the final version. But it's a testament to just how involved and complicated the government processes are to try to reach out and deal with this crisis. We don't have the final version. And the final version, if it's anything like the draft, is going to be over 800 pages long. So the sections that would immediately concern us as practitioners and office managers and owners are the so-called Paycheck Protection loans that are in my middle panel here. This law authorizes emergency SBA Paycheck Protection to help cover payroll costs, healthcare, rent, utilities, and other expenses incurred during the crisis. And that would include this window of February 15th through June 30th of this year. We also know that the law is providing funding for tax rebates to individuals with additional payments, and these rebates are at a descending scale up to a point where incomes of over $75,000 a year will not receive these benefits. Okay, so Paycheck Protection. I'm going to preview. Now, this is a whole scheme to, one, support the workforces even if they're sitting at home. This is a supplement and a complement to the leave laws. It allows us to gain government money to pay out on these limits, either the average monthly payroll costs during the prior year times 2.5, or 10 million, whichever is less. I'm going to guess that our listeners are going to have 10 million in payroll. So we're talking about an average monthly payroll times 2.5 as the loan amount that's available under this payroll Paycheck Protection program. Now, that amount can be forgiven, not paid back, as long as it's utilized for certain purposes and within a certain time frame, and certain other actions are taken by the employer. So first off, it'll be forgiven to the amount equal to the amount spent on payroll, interest on secured debt, rent, and utilities in the 8 weeks following funding. And the forgiveness, though, can be reduced if the employer reduces its workforce during that 8-week period relative to prior pay periods, or reduces its compensation paid to an employee during that 8-week period by more than 25% as compared to the most recent calendar quarter. Now, there's a comeback to that if an employer can avoid that reduction if the employer rehires all of its employees laid off since February 15th or increases their previously reduced wages no later than June 20, 2020. So we have this narrow window of a couple, 3 months where we are going to be able to utilize loans to keep our employees and our own offices running and the overhead, as long as We don't reduce pay, reduce workforces, and we get everybody back. If we have reduced or any of that, if we get everybody back by the date of June 20. So again, this is brand new. Final version hasn't even been printed yet, but these are the broad outlines of what's available. Okay, now the new law also expands unemployment assistance. And this is going to be different in every state. But the idea here is that in addition to whatever the states are paying out, the federal government is going to be adding money to prolong unemployment benefits. So the point of the first bullet point here is that the Act provides unemployment benefits assistance when the worker is not entitled to any other unemployment. So that's why I say it's going to vary from state to state. In California, we have a 26-week eligibility period for unemployment. Florida, I learned the other day, I believe has a 12-week benefit duration. So this benefit is going to kick in different states at different times. The idea here is that the benefit, once the federal government money is available, is going to be the amount under state law, which is going to vary from state to state, of course, and an additional $600 for 4 months until July 31st. And while the additional amount per week of $600 is only available for that 4 months, this new law is going to expand the maximum entitlement to 39 weeks beyond typical time of any state. As I said, 26 here in California. It may be shorter or longer in other states, but we're going to have a uniform unemployment benefit window of 39 weeks going forward. All right, so that is your nutshell introduction to this new world we have in the workplace. This slide will show you our contact information, as I said, our phone number there, email addresses. You're welcome to email me or Amy Rosales, our office manager. The address is here. And we will get you the PDF promptly of this entire show, this entire presentation. And as I said, we can give you a sample employer precautions policy that we are just developed, so you can take a look at that. Again, none of this is legal advice, as I said, and would have to be fine-tuned to in conjunction with your own lawyer or with our office on a one-on-one basis to make sure it applies to your own circumstances. So with all of that, Gillian, do you have any questions now that you might anticipate others asking of me?
I do. I have a couple. That was great, Tim. Thank you so much. I have a couple things that I think are pretty important. The first is the fact that some offices are reporting that staff don't want to come into work just due to concerns, health concerns, and virus concerns. If that person is vital to patient care, is there anything that a manager can do if that person can't work remotely? Is there anything the person can do remotely? Can you touch on that?
Well, yeah, thanks. So first off, the question in terms of what folks can do remotely, I mentioned the promotion activities, the other stuff, the normal administrative stuff that might go on site available. Another option that we've helped other dentists with is what about having those that perhaps can only work productively in the office doing something in the area of training or continuing education while they're home. And that's feasible. It would be time that would be payable to that person, and all the teleworking principles that we covered earlier would kick in. But it's entirely feasible for somebody to study continuing education, whether it's in their own field or office operations, what have you, to work remotely on that activity for compensation. Yeah. There was one thing that I didn't mention that viewers might have a question on. I mentioned the exemption, potential exemption for payrolls of less than 50. That's in the panels on economic hardship and impact. If it's going to put a company in deep trouble, viability-wise, don't have to extend the paid emergency leave and the unpaid if it comes to that for the childcare over the 12 weeks. There's another exemption that people have heard about, and that's for under 25 people. The whole concept of leave is reinstatement. That's probably the key point, whether it's paid or unpaid. When an employer is applying this law, it's to bring the person back after the conditions that required the leave have expired. So what that means is that it's a promise that we as employers will take that person back to the same or equivalent position once the emergency is over, or the conditions at home are resolved. Now, the exemption of less than 25 is a special part of the Emergency Family Act, which indicates that a business of that dental few people can also have the leave law waived under certain conditions as well. So these are all within the online FAQs that I mentioned to the Department of Labor continues to post. So I just wanted to mention that as well.
Great, thank you. Just to our viewers, I want to let everyone know that we do have links above to all sites referenced in the webinar, including links to the FFCRA questions and answers and poster, along with the work sharing programs and unemployment benefit durations state by state. So go ahead and check those out. And Tim, thank you so much for joining us today.
You're very welcome. Thanks for your time.